we have to talk a little bit more about a geeky issue involving the default provision as to whether or not a state can ban guns on all private property unless you get permission from the owner to carry your gun on that property. Or alternatively, which has been the default position in American life from the beginning of time really, you get to carry your gun on any private property unless they tell you you can't. Let's talk about it. There's a point I want to add to our previous discussion. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do show your love for the right to keep and bear arms. And please like this video and share it widely. And also feel free to follow us on Twitter as well. All right, folks. So I just recently shot a video talking about how some states like New York and New Jersey are trying to change the law involving so-called sensitive places, which, as you know, is a euphemism for government-mandated gun-free zones. And they're trying to do it in one particular way. In addition to labeling certain places sensitive places where you can't bring a gun, even with a carry permit, places like churches or banks or hospitals and so on, there's another thing that they're doing, which I like to call the default rule, or perhaps the restricted places rule. The way it works is, historically in America, you could bring your gun, even if you had a concealed carry permit, let's say, on any and all private property, unless you were told you couldn't bring your gun there. So you could bring a gun into a person's home without a debate, but if they asked you to leave because they don't want you there with the gun, well, then, you had to leave, or you were basically committing trespass. So what happened in places like New York and New Jersey is they've tried to change the default or the presumptive position in a way that's entirely inconsistent with American life. Now, so what the New York and New Jersey legislatures are trying to do, and have done in the law at least, is they basically have said that all private property in their respective states is a gun-free zone unless the owner of that particular place, whether it be a gas station, a hospital, a convenience store, a supermarket, it doesn't matter, unless that particular owner of that particular place puts a sign out front or otherwise gives you express permission to bring your gun onto that piece of property, you're not allowed to bring a gun onto the property. So obviously the plain text of the Second Amendment is impacted by virtue of the fact that if you are restricted from where you carry a gun, that impacts your right to keep and to bear, which means to carry a gun. So as a consequence, of course, once the plain text is implicated, the burden shifts to the government. In these cases of New Jersey and the state legislature of New York, the burden then shifts to the government to show that there is historical analogues that prove that there is a long-standing tradition of this kind of gun control law in American life going back to the founding. The classic example I like to use of this sort of thing is that it was illegal to use a firearm to commit murder at the time of our founding. That remained the case all the way up to today. You're not permitted to misuse a firearm to commit a robbery, a rape, or a murder. That's the kind of long-standing tradition of restrictions on the use of a firearm that satisfies the Second Amendment and would not violate the Second Amendment if you ban the use of firearms or the misuse of firearms to commit those kinds of crimes. So again, the government bears the burden in this instance to show that there is a long-standing tradition of preventing people from bringing guns onto property, private property, unless they first get express permission from the owners, which is simply not doable. But that doesn't prevent the anti-gunners and the governments from trying. Now, New York and New Jersey are trying to justify this shift in the default from you can carry a gun anywhere unless you're banned to you're not allowed to carry a gun anywhere unless you get express permission. So the question is, are there any historical analogs that the government can point to? Well, they've tried to point to a few, and we've talked about in prior videos how it's not successful. First of all, a lot of the historical analogs the government has been pointed to are way too late. These are late 19th century historical analogs where they try to claim this somehow justifies what they're doing, but this is after 1791. It's way after the founding of America. And because it's after the founding of the United States and after the creation of the Second Amendment in 1791, these historical analogs from the late 19th century do not teach us what the founding fathers thought was protected by the scope of the Second Amendment. So anything after the Civil War is way too late, and certainly anything in the 20th century is way too late to teach us anything about the scope of the Second Amendment. That's number one. But beyond that, a lot of the examples, we talked about this in a prior video, are really, if you go back to the founding era where it talked about restrictions on where you could bring your gun, these were really, these were hunting rules. These dealt with issues involving like where could free native tribesmen hunt, when you could hunt deer, where you could hunt deer. Again, these were really hunting regulations. Some of them involved anti-poaching regulations. For example, you see certain regulations involving trap guns where you're not allowed to use trap guns to hunt game for various reasons. Again, a lot of the rules the anti-gunners have come up with in these cases in New York and New Jersey are really dealing with hunting rules or anti-poaching statutes. In the last video I also did, I drew your attention to some scholarship that had been done. I put the links to it down below. I'll do it again here, where a lot of the laws from the 18th century dealt with restrictions on carrying guns, which under the definition of a gun by Noah Webster in the early 19th century, and the way the word gun was used in the time of our founding, a gun referred to either cannon or a long gun, such as a musket or rifle. And what a gun did not include, as Noah Webster taught us in America's First Dictionary of American English language, we know that a gun did not include, I repeat, a gun at the founding era did not include within its definition a pistol, a handgun. This is particularly and hugely important from a legal point of view because all the restrictions and regulations that the anti-gunners in the state of New York and New Jersey have come forth with, dealing with regulations as to where you could bring your gun, do not speak to where you could bring your pistol or handgun for the purposes of self-defense. So as you know, I talked about these arguments a couple days ago, but then I was talking to a friend of mine and I pointed out, and he complimented me on the prior video, and he says, wow, that was very geeky, but very helpful. I never heard any of that stuff. And I said, yeah, and I actually gave him another point. He said, why didn't you make that point? I said, well, I felt the video was going too long, and I thought it was already too geeky. I didn't think people would be interested. And he admonished me and says, nope, you got to do another video and add that extra point because people need to know there's yet another reason why the founding era laws restricting where you could bring a gun are completely distinguishable and not persuasive historical analogs. And that is the point I'm about to make here because I didn't make it in the prior video and I probably should have, but I thought it was running long. Here's the point. If you look at the statutes, and I'm going to read some of these things to you, if you look at the statutes that the anti-gunners or the gun control people are using, a lot of them refer to preventing guns, which as you know are long guns, they're not pistols, but preventing guns from being brought onto lands. This is a key distinction that I want to add to this video and I want you to take with you because I didn't mention the last time. There is a distinction at the founding era, and I'll put some citations to some cases and stuff below in the description of the video so you can check it out, see if I'm right. During the founding era, where there were restrictions as to where you could bring guns, if you read those statutes carefully, they talk about preventing you from bringing guns onto certain lands, or things along the lines of lands. Preventing people from bringing guns onto lands at the time of our founding is totally different from what the anti-gunners and the states of New Jersey and New York want to do now, which is they're trying to prevent you and I from carrying a handgun, a pistol, on our body concealed, pursuant to the permits we have in New York and New Jersey and the like. They're trying to prevent us from bringing guns on places, specifically into taverns, into stores, into buildings, into facilities. You see the key difference? If you read the statutes at the time of the founding that restrict the use of guns, long guns, to bring it onto lands, did you hear the distinction? The founding era rules deal with the lands and not buildings, which speaks to hunting and anti-poaching. It doesn't speak to carrying a gun peaceably, or I should say carrying a pistol or handgun peaceably into a supermarket, into a shop, into a tavern, into a restaurant, and so on and so on. Give you some of the reasons why this is important. Let me give you a couple examples out of a legal brief I'll link to down below that I think you'll find interesting. Here's a quotation from a New Jersey statute that the anti-gunners are trying to use. This is a New Jersey 1722 statute. And it talks about, ready, enclosed land. that reference to enclosed land, which is land, can also be found in a founding era New York statute and a Pennsylvania statute. You see, they're talking about land, i.e. where you could hunt, where you could fish, where you might engage in illegal poaching, but not a building, not a tavern, not a restaurant, not a shop. Let us carry on. The state of New Jersey talks about that improvements is a legal and technical word and means enclosures or enclosed fields, lands fenced in, and thus withdrawn and separated from the wastes or common lands. You see that? That's New Jersey, all talking about lands. None of these statutes that the anti-gunners cite to refer to buildings. And that's my key point. That they're trying to say that you and I cannot bring our gun that we have pursuant to a concealed carry permit in these places into a shop, into a restaurant, into a big box store without first getting permission. And to justify that, the states are using historical analogues saying there were restrictions as to where you bring your guns, but none of the statutes they're talking about say you couldn't bring your guns or pistols, by that way, or for that matter, into particular buildings, which is what we're really talking about in modern America. So, very important distinction that I want you all to be aware of. This just goes to show you that the historical analogs restricting long guns on lands at the founding era that the anti-gunners today are trying to use to prevent you from bringing a gun into a big box store or a restaurant without getting express permission from the owner, the historical analogs are not analogs at all. They're totally separate. They don't teach the point, and they do not serve as a long-standing tradition in American life for preventing us from bringing our firearms onto private property unless we first and foremost get express permission from owners, which is absurd because the truth is I go to all sorts of places all the time, restaurants, truck stops, shops, big box stores, and I don't even know who the owners are. I don't even know where I would get permission if I had to reach out to them. That just goes to show you that not only is it absurd, but as a practical matter, it's entirely inconsistent with American life, which means the government cannot satisfy their burden of showing there is a long-standing tradition of a restriction of firearms on par with, again, let's say a long-standing tradition and rule saying that you cannot misuse firearms to do things like commit crimes. So there's just two additional points I want to make about this critical add-on, which is the different distinction between lands and buildings. At the time of our founding, one can be a historical analog potentially on hunting regulations. One cannot have anything to do or has nothing to do with carry in guns peaceably for self-defense. And that is two things. One is, as far as I can tell from looking at the scholarship, the gun controllers, the states have not been able to come forth with anybody that's ever been convicted of simply carrying any kind of a firearm, including a long gun like a rifle or musket, on lands or anything. So to the extent they point to these laws on the books, it's unclear any of these were ever enforced. So as of this point, I don't even know if some of these statutory bans really ban individuals carrying any kind of guns, including long guns on property, because again, there's no evidence that anyone was ever convicted of these laws. So that's another point to keep in mind. And the last point, I just want to read a quote from you, Nysurper versus Bruin. This is a great quote. It's getting lost quite a bit. That's why I want to bring it back. It's such an important thing to keep in mind. Basically, what this quote from Nysurper versus Bruin, the U.S. Supreme Court, is teaching all of us is that when there is doubt about whether or not a historical analog or historical law is pro-freedom or anti-freedom, we should always assume it's pro-freedom, pro-Second Amendment, pro-gun rights, if you will, because that's what not what I taught you, it's what the U.S. Supreme Court has taught us. This is Nysurper versus Bruin, the U.S. Supreme Court. Here's what they write, and they do it in the context of analyzing some ambiguities associated with a case called the Sir John Knight's case, which interpreted the famous statute of Northampton that the anti-gunners spent a lot of money and a lot of time trying to use to justify taking away our right to keep and bear arms outside the home. The court writes, quote, "To the extent there are multiple plausible interpretations of Sir John Knight's case, that's the Supreme Court, we will favor the one that is more consistent with the Second Amendment's command, period, close quote. There's a great quote from the Supreme Court. Do not forget that quote. It's extremely important. If there's any ambiguity or confusion or debate about what a law historically means, the presumption is in favor of the Second Amendment's command. And for those of you who like to tweet out and put comments below, shall not be infringed, exactly 1000% correct. And that's not your tweet. That's not your comment down below. That is the U.S. Supreme Court that says, when in doubt, favor the one that is more consistent with the Second Amendment's command, period, close quote. You're absolutely right. And the United States Supreme Court, when they read the Second Amendment, agree with you 100%. Okay, folks, I hope you learned a little bit something today about the difference between lands and buildings when it comes to historical analogs and what can be justified in the default fight over where you can bring your gun in these blue states. I hope you learned something again. If you haven't subscribed, please do so, and we'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.